Professor, thank you very much for that correction as well. We're very happy that
Thank you.
you have joined us here on the phone line. I mean, since yesterday, we've been talking to quite a number of people, and they've all been giving their reactions to this decision taken by the Court of Appeal. What's your own reaction, even before we begin to get into the other issues?
Well, thanks for having me. I think that we all seek for justice and we want justice to prevail. So if something goes wrong and it goes to court, due process has to be followed so that the person who is alleged to have committed a wrong would be held responsible and due punishment inflicted on that person. When we talk about criminal law, the principle or the basis for determining culpability is to establish a case beyond reasonable doubt. So it certainly places a higher burden on the prosecution to establish the guilt of an accused person as compared to a civil case. Now, if it's down to um, the ambulance case, certainly a lot of costs have been incurred by the state, more than 2 million euros and so on. So it's a big amount of money that could have been used for different purposes. But the question is, um, in what way can we determine who is guilty and who should be held responsible or who should be claimed to have caused financial loss to the state? I think the way the case went, and if you look at the whole brouhaha surrounding it and so on, I guess we all know about them, so we don't need to go into the details. I think that at the end of the day, the decision rendered by the Court of Appeal is the right decision. And because when you look at some of the issues that were raised by the Court of Appeal in its decision, it tends to suggest that probably Mr. Fortune was the wrong person to have been identified for prosecution in the case, and Mr. Japa as well, because for a number of reasons, Mr. Fortune was not, if you talk about letters of credit, for example, it has to be something that is, is redeemable and it is subject to a particular condition being met. So if the point is made that you is the one who committed the act, the question then is, at the point, a certain condition that should have been satisfied. And that responsibility was not on the Ministry of Finance, but rather Ministry of Health. So I've been making the point that probably the wrong person is being prosecuted. And so instead of going on appeal to the Supreme Court, why don't we the Attorney General sit back and analyze the judgment carefully and decide that probably we are looking at the wrong culprit. You all need the money to become, you all need to the money to be recovered to the state. And I think that is also should be the focus of the Attorney General, because in the criminal justice system as you have it today, it's not just about the deterrence approach or incarcerating somebody, but also if it is a possibility of recovering money. That is what, in fact, introduced the plea bargaining deal into our criminal justice system. But we know how it was botched by the Attorney General and issues related to that, which we all know already. So, did we find the right person to prosecute here? And the judgment also indicates that there are certain facts or issues which the Attorney General could not prove or did not prove. Maybe even if it goes to the Supreme Court, you may have the opportunity to do that, I don't know. But, of course, if the case should go on appeal, it will certainly enhance the jurisprudence, criminal justice jurisprudence. So that in itself, I think it's a good thing. But the reaction of the Attorney General seems to add to the perception that he seems to have a personal vendetta with especially the first accused person. Nobody knows his real intention, but we're just reading at his conduct in the case concerning plea bargaining issue that came up, even um, paving the way for the judge at the high courts, Justice Sophia Butcher, to actually advise him to recuse himself from the case. And describing the judgment of the Court of Appeal as perverse, I think it's something that shouldn't come from the Attorney General. So looking at the case, putting everything together, it is plausible to come at the conclusion that, or to arrive at the conclusion that there seems to be something beyond merely prosecuting a criminal case, which we probably is influencing the way the Attorney General is trying to prosecute this case, which therefore lends the perception, as especially the position is saying, that probably is moved from the realm of prosecution to persecution. Yeah, so that is my take on this issue, on the case.
Right, and talking about the Attorney General, you mentioned that his reaction to all of this, feeds into certain perceptions that have already been formed. The Ghana Bar Association has condemned some of the comments that he made in interviews that he granted, and of course in the statement that was issued. They find it quite unpalatable. Would you? I believe that you agree with the Ghana Bar Association on their stance on this.
I do, and I was pleased to see that reaction from the Ghana Bar Association, because previously their reactions to the Attorney General's behavior or professional attitude has been silent, and the silence has been too loud. So I was pleased to know that the bar is finally coming out to criticize the Attorney General the way it did through its public relations executive, Mr. Xavier. So I think that this is the approach that the bar should adopt all along, because the Attorney General is the head of the bar. The Attorney General holds a very prominent position in our legal system, and he has the power to prosecute all criminal cases, civil cases, and so on that involve the state and his hands, and he has to set a standard that others can follow. And if you consider the fact that his behaviors and his attitudes violates the professional ethics of the bar, then certainly there's reason to question his conduct and his motive. And I think this is what the bar association should stand up to. So, in my opinion, that was a good reaction, and we are looking forward to finding such ways to police the functions of not just the Attorney General, even if it's the Chief Justice, and we deem her behavior to be not appropriate. We should have the freedom to comment on that and to make sure that we check each other in what we do. We don't claim to be perfect, so that's why when somewhere along the line we fault or we do something that is wrong, we should accept constructive criticism and to respond to that appropriately.
And during the trial, which was happening at the High Court, which essentially now is no more because of the Court of Appeal's decision, there were certain details that emerged, and certain accusations that were leveled against the Attorney General, right? And there was an audio that leaked that we all know, which purportedly puts the Attorney General in a negative light because he was seen as trying to coach, a witness, telling him to take sick excuse duty so that they can manipulate the court processes somehow, among other things. On that particular score, should we be looking at taking some action, or the General Legal Counsel taking this up and looking into the Attorney General's conduct?
Well, that is something that can be done by the General Legal Counsel. But, of course, if things are done fairly and due process is followed. But some have concerns about whether that process can work, considering first of all, the silence on the part of the bar, for example. But now that they are speaking, maybe that will continue if the Attorney General continues in the trajectory that he has been following. But if you go to the Legal General Counsel, for example, the Attorney General is there. He has a big role to play there. There are some also looking at the possibility of maybe going to Starr. I don't know if that may be a viable option. But certainly, the Attorney General cannot be left to do things in his own way. That is why, for example, the advice by the courts for him to accuse himself is one of these things that would have made him realize that probably he's going a bit too far. Of course, we have entrusted such big responsibilities to him. He should be able to execute that to ensure that justice is served and money that is due the state do not get lost and so on. But the approach, the style is also critical because there are ethical issues involved which need to be handled carefully so that it sets a precedent set by previous attorneys general in the country. And so there should be a way for him to hear and to heed to advice, for him to do what is right. But I think it may get to a point where there's been situations where attorneys general have been sued or referred to other bodies. So probably that day may come, but we're hoping that it won't get there, and the attorney general will probably heed to advice and do the right thing. There are a lot of things that he has done that has helped save some money for the country and to improve the justice delivery in the country. But we are saying that there are certain areas that there's a need for improvement. And so that is what should be taken in good faith and something done about it.
There are those who believe that in the aftermath of all of this, perhaps the Attorney General should be relieved of his duty as Attorney General. There are some people who have said that. Is it something that you also subscribe to?
Well, maybe that would be going a little bit too far. But I know that in some jurisdictions, an Attorney General behaving the way he has behaved would have actually resigned his position. And some jurisdictions that so happened. And so that is one of the options which, especially when the plea bargaining deal came up, one was expecting. That failing, one of the options also was for the president to have given him the sack. But that also didn't happen. And that was also sort of expected because we've seen how after that the president has sought to shower praises on him. Of course, he deserves those praises for what he has done in those circumstances. Yeah, but the president didn't do that. So there are other situations where he could have resigned, but if he didn't do that, probably it hasn't reached the threshold where we can say that he should be given the boot. But in some situations, in some decisions, that would have been the case.
Now, let's switch our attention to, something else, which has got to do with the judiciary and the courts. With regard to appointments, to the courts, there has been this debate about whether or not there should be a cap put on the number of Supreme Court justices, among other things. Where do you stand with regard to that? Do we have enough Supreme Court justices? Do we need to appoint more Supreme Court justices? Looking at the workload at the courts, as has been told to us by the Chief Justice herself.
Well, it depends. I think that the Constitution says a minimum of 9. There's no cap on the maximum number, but that in itself is a source of concern, and people are concerned that that is subject to abuse. And from I think throughout every regime, there have been criticisms about the way of appointment and the number of appointments to the Supreme Court and so on. So that tells a story that as a country, we need to look at this matter carefully and to come to a decision. There's also the perception that justices are being um, uh, thrown into appointment positions and being made judges in order to, provide a sort of shelter or as a fortress for some governments, because these people are supposed to be people who are sympathetic to a particular political party or regime. That perception is also there, which means that we have to review the process of appointment of judges. There seems to be, of course, you have the Judicial Council and so on, but there seems to be a large chunk of power that rests in the president to influence the process, especially the fact that overwhelmingly he has the power to appoint the Chief Justice. And if the Chief Justice is amenable to the wishes of the president based on the fact that probably the Chief Justice was appointed as a sort of reward, and I'm not saying that has been the case with any Chief Justice, but if that it starts from the top, there's a local proverb says that if you cut the head of the snake, the rest is like rope. So if it begins to rot from the top, it can come down to the other levels of the court system, whereby the Chief Justice also wields some power and influence, to be able to influence the process there. So I think that it's a debate that we should have that can help us to come to a conclusion. So I will not be able to conclude here that there should be 10 judges or 15 and so on. We should look at a number of factors, which I think will involve the bar, the bench, academia, probably the general public, so that we have a debate about this and we will be able to come to a decision which will ensure that justice is delivered, the integrity and independence of the judiciary is maintained, and trust in the judiciary by the general public is held to a very high standard that is critical for our democracy, because it's the judiciary that is sort of policing the executive and parliament. And the judiciary, they are not members of the judiciary, are not appointed, are not voted or elected by the people. So the process of appointing them to office is also, so long as it stands, as the rules generally are laid out, seems to have worked well for us. But the fact that the issue about the number, the caste issue at especially the Supreme Court, and then the fact that the way some people are being appointed are being questioned, that means that we need to look at, I think, particularly that specific area and the way the Chief Justice is also appointed, so that it will forestall any exceptions or any biases which probably the ordinary person may not understand and we come to that conclusion. But in reality, that is not what is happening. But perceptions tell a lot about how people see things and how they react to things and how they want to identify with and use a particular system or process that has been laid down. And so there's a need to engage in a national conversation around that.
Very well. Prof, thank you very much for speaking to us this morning here on the Morning Star.
My pleasure. Thank you.
It's been great having you. Professor Kojo Epiaje is Associate Professor at the University of Ghana. He teaches at the Law School at the University of Ghana, speaking to us this morning here on the Morning Star. There's still more to come here on the show. There are more conversations that we will have on the Morning Star this morning, and so we urge you to stay tuned